Civility is no small thing, because after all, the lawyers want to convince the judge of something. People always want to buy from those people that they like. So does it influence a case? Much more than you would imagine. Young lawyers come in and believe if they have the right side of the law in their perspective, they can behave in any way they want. And the law and the righteousness of it will come to the top. But you can lose a lot of ground when you don't do a couple of things or when you overreact. And we have a challenging time because there's so many judge shows and so many law shows that people are naturally thinking that they should emulate this kind of behavior to their detriment.
It's interesting because I think one of the things that I see happening a lot is law school does one thing, it teaches you theory, but it doesn't necessarily teach you the practicalities of your practice.
I never learned it.
Right.
I never learned it. And when I first started going in, I didn't know how to respond to somebody who wasn't being civil. And I thought that the judge perceived this as strength and power, and I thought that the judges were getting intimidated by that behavior. So I didn't know whether I should be like that or whether I should keep my dignity.
Right. And I would imagine that in the end, always err on the side of keeping your dignity. I'm not sure that that's something that you would agree with, but knowing you as such a dignified person.
Well, I would never say it was erring on the side of. I would say that it is a power strategy.
Right.
And it is not a default strategy. That when you present a case that is well thought out, that is strong, and presented without the invective or the coloration of your client, it has a tremendous amount of credibility. And to take personal attacks on other people, which they're fighting, the lawyers are fighting. In real life, sometimes you do take personal attacks. Never in the courtroom. When I see people taking personal attacks, I think their facts aren't very good.
Interesting. Let's talk a little bit about, as the young lawyer, he comes in, he or she may, of course, be subject to the idea that, you were talking about television shows and you were talking about the drama of the law series as we see it. I imagine a lot of these young lawyers feel they have to emulate some of these characters on television to some degree, and of course, that's not the way to behave in the courtroom.
Well, first of all, if you're going to trial, you want to appear to be tough. We all have seen for 25, 30 years intimidation of witnesses. So that's wrong. You want to be very dignified. You want to have clarity. You don't want to make personal attacks on witnesses. You do want to put the pressure on only as a strategy. For example, if you think somebody is lying and you know you can foul them up, or you think somebody may be guilty of domestic violence and you want to show the judge their temper, there are ways you can lean into the witnesses and be more aggressive as a strategy. But across the board, it looks as if you don't make a point when you need to. When you bark at everything, it's like crying wolf.
Right.
The judge doesn't hear it all. We want to hear, we want to feel good about what we do. And the way we feel good about what we do is if we don't have two lawyers looking like two fathers fighting it out at their kid's soccer match. We want to feel dignified.
Right.
And we want somebody who's going to reflect that for us.
So it's interesting because, in the scheme of it then, as they're looking towards their strategy, which I think is a brilliant way of putting it, they have to pick those points. They have to understand in telling their story,
right?
Okay, I'm on this keel and I'm doing this all the way, but now here's my point. And
for example, a lawyer that would impress me would be accommodating about dates, would not default if somebody's late, would not be overburdensome in discovery, would not be abusive in discovery, so that if you would not take personal attacks, would sit back in a pretrial and present their case without telling the other person that they're an idiot. This happens because we're all human.
Right.
So that if somebody is accommodating and dare I say classy in some ways, when they get to the point that really matters, they will have already established with me a certain credibility. So the point that really matters is going to be highlighted and more neon, and I'm going to notice it. and I'm going to tend to believe it.
That's great. So that's the strategy in front of understanding how the judge can listen to your story and how to get emphasis on your points.
And the other way, and that also bleeds over into trial objections, for example. There are some lawyers who object to everything. Then I start to believe that none of it's really objectionable, and they're just trying to trip up the other side. Well, sometimes that can be a strategy when something dangerous is coming in, and you want to see if you can't dismantle it. But when you're objecting to everything and causing a drain on everybody's energy, then when you get to the real objectionable thing, that one document, that one piece of testimony, it might get lost in the ocean of objections.
Right, right. What else do you advise for the young lawyer as he appears before you or the tribunal?
Well, this is commonsensical, but the idea of being well prepared. Too many lawyers come into court, and I'm not saying I didn't do this too when I was a lawyer,
Sure.
and just kind of winging it. You always know when somebody is winging it. You want your documents ready to show the judge. You want to be able to present your case as if you really want the judge to understand it. People who yell their case, or like this and talking like the other person, it's organic, it's brain chemistry. People can't take in information like that. When people yell in my courtroom, I say, I don't hear anything above a certain decibel. I'm not taking it in. Now, if you're saying it for your client and you think that's impressive, that's one thing. But if you're saying it in a way that you know that I understand, and people may want to look and see how judges understand. You may have a pleading judge who loves to read. You may have a judge who needs to hear it auditory. You may have a judge who loves flip charts. Everybody takes in information differently, and it's not a bad idea to try and figure out how the judge takes in information. If you have a screaming lawyer on the other side, and people ask me this all the time, what do I do? Shouldn't I? My client expects me to be as powerful or to be as intimidating. Then you have to micromanage your client in advance. You have to say, they're a screamer. Do you want me to scream back, or will you be okay if I do it my way with dignity and intelligence and strength? This way, they're not feeling lost when they hear what's happening, and you can maintain that good appearance in front of the judge. Or you could say to the judge who's letting it go on, Judge, do you want me to scream as well? Do I feel the need to get through to you that I need to do this? I think we should do this on a different level. So that's a way to handle it, because that is always a problem.
Well, it's interesting, too, because I think from a human point of view, which is really important, is you're telling the lawyer, look, first of all, you have to do your homework. There's no doubt about it that if you come in not prepared, it's going to show. Secondly, you're asking the lawyer to say, know your parties as well as you can. Try to understand who your judge is as a person. Try to understand who your client is as a person. Try to understand who your opposing counsel is as a person, I would imagine.
Yes.
Because that's going to give you more ammunition in terms of the way you can deal with them personally, the way that you understand them personally. So it's kind of like know your enemy, know your opposition,
right,
and know your friends.
And I want to say something about courtesy copies. And courtesy copies are giving the judge in advance anything that's going to be a little complicated. Because the last thing you want to do is say, here's a 40-page memorandum, and we're ready to go to hearing. Because what you've done is, really, you've put the judge in sort of an uncomfortable position. Do they go on the back, spend an hour reading your pleadings when you could have delivered them? So that's something that you really should do. And when you are citing law, ask the judge, do you want me to give you the case law? Just ask them how they want this. Stipulations. When at all possible, show the judge you're willing to stipulate to those facts that aren't in controversy. Otherwise, you're asking the judge to put in hours and hours of extra time just trying to get in the fact that a house was bought and this is the deed.
Right.
So you want to try and be as respectful as you can of judicial time. And you want the judge to know that that's on your agenda.
Right. Very important. That's
yes.
That's excellent.